Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined.
Yes, Deputy President Rigathi Gachagua has suffered a setback after the court coming out to say that it won't block the Senate from carrying out the impeachment procedure. We all know DP Rigathi Gachagua went in court to block the impeachment motion from getting to the Senate. And today he has suffered a setback. But we also remember that during the Kericho Governor impeachment proceeding, the Senate, the Speaker of Senate, Amason Kingi, came out to reveal that the courts should not interfere with the impeachment process. And I think I give thanks to the courts of law, because courts of law in Kenya have upheld the sanctity of constitutionalism and human rights. Although I'm an ardent supporter of the DP Rigathi Gachagua, and I know deep in my heart that he's going to be let off the hook by the judiciary, but it was not supposed to block the impeachment motion from proceeding to the Senate. So in this episode, I've come to talk about the statement which was made by Amason Kingi and the ruling which was made by the judge, allowing the impeachment motion to proceed in the Senate, what it means for our politics, and most importantly, the study materials we can learn from the politics of our nation. But before I do this, I want to let you know that if you're new to this channel, please subscribe. If geopolitics and economics is what you want, this will be definitely the right channel for you to subscribe to. So we all know that DP Rigathi Gachagua is fighting for his political life. When this came after William Ruto giving it a green light for his impeachment. And I keep on telling people that day Gachagua is going to be let off the hook by the judiciary. Come 2027 is going to be the president, and I hope he doesn't resign. Okay? So today, the judiciary has come out to announce that the impeachment motion should proceed to the Senate. DP Rigathi Gachagua had run to court to block this impeachment motion. But before that, yesterday, it was an impeachment motion of the governor of Kericho. Amason Kingi had warned about this, had warned courts not to interfere with the arm of the Senate. And court cannot interfere midway, because normally court comes in after the end process where everything is done, so that the courts can look at merits and demerits of the cases to make its ruling. Before I proceed, let me first give you the tape as Amason Kingi was warning this. Here is the tape.
And the judiciary compel any action to be undertaken by Parliament. I rule any injunction interfering with the work of Parliament has no effect on Parliament in exercise of its constitutional functions. Such court orders have no effect on the National Assembly or the Senate or any of their committees, respectively. In the unlikely event of any such orders, Parliament and its committees shall proceed unabated, unfettered and unhindered, as may be directed by the respective Speaker of Parliament. Now, the question of the effect, if any, of the court orders injuncting the Senate from conducting any business is well settled. And this
So that is the Speaker, Amason Kingi, warning the courts that they shouldn't interfere. And I'm also saying that it was the right thing, because the courts cannot come in midway. I know DP Rigathi Gachagua is trying not to give it any chance. He uses any chance he can have in his power to block this. But the court made Amason Kingi was right. I know at the end process, Gachagua is going to become a winner, because these cases are frivolous. They cannot hold anything in law. I know in the Senate, Gachagua will be impeached, but will be let off the hook by the judiciary. So those were the words of Amason Kingi. So today, even the courts of law have come out to pronounce itself to say that They cannot interfere in a process before it ends. In fact, the work of the court is supposed to look into issues that have ended to see if they take the legal threshold. And I think they are right. Today, the judge came out to announce that the impeachment motion of Rigathi Gachagua is supposed to go on. And it's not supposed to be blocked. It must continue to go in the Senate. Let me first play with the tape. Here is the tape.
Is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2 sub-article 4 of our Constitution is not only the hope but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition EU522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165 sub-article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on course. Thank you.
So that is the judge who came out to say that the impeachment motion should be let free to go in the Senate. And in my opinion, as a person who understands, as a paralegal, the judge made something good, because you cannot come out to block an impeachment motion in the process. Because even if they suspend it, it will eventually reach the Senate. So, but this comes about because Gachagua is not letting any chance slide without trying to utilize it. Okay? So, I think Gachagua should go in court after the Senate doing its findings. All governors who have been let free, they have gone either to the Senate, then go to the court. Even Kauri Mangwaza was impeached in the Senate, but right now is fighting for his life in court. That is going to happen. And these frivolous charges, Gachagua is going to come back as a winner. And in 2027, he will be the president. So the judge has made a credible ruling. He cannot interfere with the parliamentary process. They were in the same page with the Speaker of Senate, Amason King. Gachagua is using this as a foundation to challenge the outcome of the Senate proceedings, because all these things will hold in a matter of law. This is what Gachagua is doing. In fact, many people usually call Gachagua stupid. By the way he has handled these issues, you clearly see that it's not by mistake that he's the deputy president. Okay? So, although it is a setback, but it is a foundation to fight this silly impeachment motion, which does not hold any water when it comes to constitutional threshold. So, although I pray that Gachagua is not impeached and is not going to be impeached, but blocking a parliamentary process cannot happen. The parliamentary process should first end so that the case can be taken to court to see the merits of this case. And this way, Gachagua will come out as a winner. So there is no in any way that the judge is wrong. The judge is right according to the Constitution. You cannot block a process in court. There are few instances, most especially when it is in the legislature, which is supposed to be independent. An intimidated institution, you cannot just block a process before it is done. Anything is challenged after it is done. Of course, that's my opinion. Do make your comments by commenting about this. Thank you very much for listening in. If this is your first time on this YouTube channel, I implore you to subscribe, like, and comment so that I can be motivated to do more of such videos. See you on another one. Peace.
If a state organ fails to abide by any of the values and principles in the Constitution, the court exercises its mandate under Article 165, Sub-Article 3, will come in and investigate whether anything said to have been done under the authority of the Constitution is inconsistent with or in contravention of the Constitution. It was in this respect the Supreme Court stated in a matter case that it would be reluctant to question parliamentary procedures as long as they did not breach the Constitution, and that the mandate of the court is restricted to the doctrine of separation of powers, to deciding on matters of individual rights and fundamental freedom. The Supreme Court then stated that in the exercise of their wide political powers, both the county, National Assembly, and the Senate cannot act outside the confines of the Constitution and the law. For to do so would invariably invite the court's intervention. End of quote. In other words, the constitutional are dashed to the finish line. They have constitutional imperatives that must be complied with, and if not, such infractions will not be out of reach of our Constitution. The timelines given in the Constitution are on the premise that its processes will comply with the constitutional requirement. Where there is an allegation that the constitutional imperatives have not been complied with, the affected person has recourse to the courts, and the courts will rise to the occasion and consider whether the state organ complied with the Constitution or the law. In that respect, ours is a constitution of hope and promise that institutions established under the Constitution will comply with its fundamental principles, and the promise that the Constitution is supreme and any act or omission in contravention of the Constitution is invalid. In other words, it does not matter how far the process may have gone, since no action is out of reach of our Constitution. This is what Lord Denning had in mind when he stated many years back that if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order to set it aside. It is automatically null and void without more ado, though it is sometimes convenient to have the court declare it to be so. And every proceeding which is founded on it is also bad and incurably bad. You cannot put something on nothing and expect it to stay there. It will collapse. Article 2, Sub-Article 4 of our Constitution is not only the hope, but also the promise of our Constitution that we must abide by the constitutional dictates, for any act or omission in contravention of the Constitution is invalid. In that respect, I conclude this matter, and this is what I say. Having considered the application and argument by parties, the Constitution and the President, the prayer for grant of conservatory order is declined. However, in view of the issues raised in this petition, which also appear to relate to those in petition E522 of 2024, which has been certified for purpose of appointing a bench of an even number of judges to hear, I certify this petition as raising substantial questions of law and of public interest in terms of Article 165, Sub-Article 4 of the Constitution. This file is to be placed before the Honorable Chief Justice to consider appointing an uneven number of judges to hear this petition. Given the close proximity of the issues in this petition and those in petition E522, the Honorable Chief Justice may consider whether this petition may be heard by the same bench appointed to hear petition E522. I make no orders on course. Thank you.